Good morning to all of you. Welcome to Legal Matters by Sai Sankara. This topic relates to professional ethics. Friends, previously I told you there are only two classes of advocates as per the Advocates Act 1967. Section 16 deals with senior advocates. Only two class advocates. Who are they? Senior advocates and other advocates. How the seniority is fixed? So every year, normally the High Court or the Supreme Court, that is Constitutional Court, they will, on the application of or on the so-called consent of the advocates, senior advocates, normally they will designate the senior advocate by normally taking some points, 100 points will be there. This is envisaged in the very famous case of Indira Jaisingh versus that very judge in the versus Supreme Court of India 2017. Indira Jaisingh versus Supreme Court of India 2017. So normally the criteria was that number one, because of the standing in the bar, second is efficiency, proficiency or expert in the particular topic. Such people, they are being selected as senior advocates. So the advocate, you all know the advantage of the senior advocate, that the advantage is that he need not file any wakalat. He can straight away come with the advocate on record, he can submit the arguments and he can go away. He need not file the so-called plaint, he need not file the written statement, he need not file the pleadings. So he has got the liberty. That means straight away he can walk into the court and he will be given the right of pre-audience, and ultimately that is the advantage for a senior advocate. So in this connection, please remember, age is not the criteria. Please remember. So suppose నాలాంటి వాడు 60 సంవత్సరాల తర్వాత లా చేసి నేను సీనియర్ అడ్వకేట్ అంటే ఒప్పుకోరు. నెంబర్ 1. నెంబర్ 2, 60 ఏళ్ళ వయసు వచ్చినంత మాత్రాన ఒప్పుకోరు. 35 ఏళ్ళు మీరు సర్వీస్ బార్లో ఉన్నంత మాత్రాన అక్కర్లేదు, ఇవ్వక్కర్లేదు. ఇఫ్ యు ఆర్ హ్యావింగ్ స్పెసిఫిక్ నాలెడ్జ్ ఇన్ పర్టికులర్ ఫీల్డ్. సో దీని మీద చాలా గొడవలు అయినాయి. అల్టిమేట్లీ ఇందిరా జైసింగ్ కేసులో జస్టిస్ ప్రజెంట్ చేసే జస్టిస్ డివై చంద్రచూడ్ గారు ఒక 5-point ఫార్ములాగా ఒక 25 మార్క్స్లో పెట్టి 100 మార్క్స్ కొన్ని ఇచ్చారు. దానిలో ఒకటి, స్టాండింగ్ ఎట్ ది బార్, డెఫినెట్లీ ఇట్ విల్ బి కౌంటెడ్, దర్ ఇస్ నో పాయింట్ ఇన్ ఇట్. బట్ అట్ ది సేమ్ టైం ఎక్స్పర్ట్ ఇన్ సర్టెన్ పర్టికులర్ ఫీల్డ్. అలాగే దాంట్లో పాయింట్ ప్రోబోనో కేసెస్, అంటే ఫ్రీగా లీగల్ ఎయిడ్ ఏమైనా చేశారా. సో నౌ సుప్రీం కోర్ట్ బార్ అసోసియేషన్, they are filed a memo in this particular case regarding the deletion of 15 points for the publication and interviews. And also they have filed in the same petition, they say that the intervention of the government is totally unwarranted because it is the court, it is the advocate who will discuss with each other, and they have to designate a person as a senior advocate. That's all. No interference by the government. Already we have been seeing war of words between the judiciary and the Ministry of Justice. Right. Coming to this particular case, Scba. So they have filed an application in the particular judgment seeking the Honorable Supreme Court directions, deletion of certain conditions in the points system, right, while conferring the senior advocate position. Here the first point is 15 points are allocated for the so-called interviews and also publications. Right? No doubt, definitely. Previously it was taken. So if the advocate writes some items to the press and if it is published in the journal, and also if he gives interviews on the so-called channels regarding the legal matters, he will be awarded 15 points. So this is not desirable. Why? Because only few advocates have got time to write, time to publish the articles. This does not enhance advocacy skills. Writing article and giving interviews, does it enhance the advocacy skills? No, definitely. So therefore, there is no objective criteria to award the points. So people who have got time. So advocate, it is a 24/7 profession. Daily he has to go to the court by 10:30 a.m. He has to be there up to 4 or 5 p.m. come back, he has to study the files, next day he has to discuss with his client so many days. He will be very, very busy, is it not? Of course, there are some advocates who are intelligent, who are having the art of writing, who are having the patience to write articles. Such people only can get the marks. Then what about the others? So definitely it is not desirable, and that too even by writing articles, will it improve your skill? So in the view of Supreme Court Bar Association, it is not desirable. Second, 25 points for the interview. So suppose if you appear before the channels and if you give your opinions, legal opinions, YouTube channels, all these things, interview or interaction. So this also, according to Scba, it serves no purpose, no useful purpose. So suitability will be judged by the High Court basing on the advocacy skill, basing on the knowledge of law, basing on the conduct at the bar, but not by the interview, not by the fluent speech, not by attacking the other judges, all these things. So assessment shall be made basing on the skill of the lawyer in the court. That is more important. Also, assessment may be given basing on the standing at the bar also. And another session by the Supreme Court is people who have completed 30 years of experience in the Bar Association. Definitely, these points are 100 points there are not. They should be given, designated as senior advocates. And lastly, Supreme Court Bar Association highly deprecates the union government's interference in the process of designation, because it is between the High Court and also the advocates, and state or union, definitely it has no locus standi. Right? Anyway, let us know what will happen. And the matter was posted to February 22nd by the Honorable Supreme Court of India. After the result comes out, I will inform you through another video. For the present, I am staying back. Thank you very much.